truth science.
As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Islam Moors.
My nationality is Moorish.
All right, the court will call the matter of Portfolio Recovery Associates LLC and Shatina Grady. 24C 2622.
Thank you. Good afternoon, Your Honor. Daniel Best, P58501 on behalf of Professional Recovery.
Good afternoon, Your Honor. True Science appearing on behalf of YouTube.
Thank you. Please state your name, ma'am.
Shatina Grady L.
Thank you. All right, the last time we were here on this particular matter was back on May 22nd, 2025, when I granted Ms. Grady L's request to stay this matter and compel arbitration in this case. And it was set for a review today to determine whether she had filed or we were moving forward on the MSD.
So I come today to have my motion for dismissal requested. And
ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
That's a wonderful story, ma'am. Bravo. I'm not sure if I believe it, though.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by a defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there is an issue until yesterday when my staff returned the call. Admittedly, we did receive, I show on June 10th, a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration, and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name, it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 317 at Gmail. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to, it's spelled the way that it's in the court papers that you filed suit of, if it's in front of you. You filed suit for SHATINA, okay? And then Grady. And then as to what you sent me and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said, no, but I could figure it out. You said, well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send, you said, I'll send an email or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send.
Ma'am, it clearly sounds like you should have had a lawyer representing you.
So again, you're playing games, and you're being dishonorable. You're being deceitful. You have not
Miss Grady.
Yes.
Please stop going down that line.
I'm just telling you,
Miss Grady. The reality is that you came in here and you asked for an arbitration.
Yes.
And I stayed this matter and gave you an opportunity to file that. So,
but he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this, that their people called me just now yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere that they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And
Grady,
if the court
Ms. Grady,
understand.
I've adjourned this case. I don't know how many times to give you an opportunity so that you can be prepared. So please don't interrupt me. Please do not interrupt me. Please. Today we're back here, and I'm not happy with either side. Because one, Ms. Grady, if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right, which complicates this matter even further. So if she's calling you guys, and now with that particular call, it gets rerouted, and like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Miss Grady. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting, or that's what I believe I was agreeing to provide, was the order granting defendant's motion. It's normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration.
Let's go.